Dear CSS aspirants, welcome to our next lecture of international law. Today we will discuss our next topic of today's lecture, which is the law and practice as to treaties. Now coming over to the outline of our today's topic. First, we will define the topic. Then we will discuss what is the conclusion. Then ratification and entry into force. Then application and implementation of treaties. After that, termination and withdrawal. Then we will discuss the treaty as a source of international law. And at the end, we will discuss different examples related to Pakistan. Let's start with the definition. A treaty, also known as an international agreement, is a legally binding instrument that is concluded between states or other international actors. Treaties can cover a wide range of subjects, such as peace and security, human rights, trade and investment, and environmental protection. Let's define treaties in the view of different books. A treaty refers to an international agreement that is legally binding on the parties to it. According to Malcolm N. Shaw in his book International Law, a treaty is defined as an agreement made in writing, whether between states, international organizations, or other subjects of international law, having binding force under international law. It can be concluded between states, international organizations, or other subjects of international law. Now, coming over to the second heading, which is the conclusion. Treaties are generally negotiated and concluded through diplomatic channels. The process of treaty making involves the negotiation, drafting, signing, and ratification of the treaty. According to the International Law Commission, the process of treaty making begins with the identification of a need for the conclusion of a treaty and ends with the deposit of the instruments of ratification, acceptance, approval, or accession. As the examples are the United Nations Framework Convention on Climate Change, UNFCCC, and the Convention on the Rights of the Child, CRC. Let's take a look at the conclusion in the view of different books. Treaties are generally negotiated and concluded through diplomatic channels. According to Ian Brownlee in his book Principles of Public International Law, the process of treaty making involves the initiation of negotiations, the drafting of the text, the exchange of instruments of ratification, and the registration of the treaty. The process of treaty making involves the negotiation, drafting, signing, and ratification of the treaty. According to Dr. S.K. Kapoor in his book International Law, the process of treaty making is initiated by the proposal of one or more states and concluded by the exchange of instruments of ratification or accession. Now coming over to the ratification and entry into force. Once a treaty is signed, it must be ratified by the state in order to become legally binding. Ratification may require the approval of the state's legislative or executive branches, or both. The treaty enters into force once the required number of states have ratified it. As the examples are the Paris Agreement, the Treaty on the Prohibition of Nuclear Weapons. Now the next heading is application and implementation of treaty. Treaties are legally binding on the parties to them and are generally given effect through domestic legislation or executive action. The interpretation and application of treaties can give rise to disputes between the parties. The example is the implementation of the International Covenant on Civil and Political Rights by different states. Let's take a look at application and implementation in the view of different books. Treaties are legally binding on the parties to them and are generally given effect through domestic legislation or executive action. According to J.G. Stark in his book Introduction to International Law, states have an obligation to give effect to treaties as part of their municipal law. The interpretation and application of treaties can give rise to disputes between the parties. As per ICRC Pakistan and international humanitarian law, disputes arising from the interpretation or application of a treaty can be resolved through various means, such as through negotiation, mediation, or arbitration. Moving forward, let's see how treaties can be termination and withdrawal. Treaties can be terminated through various means such as denunciation, revocation, or expiration. The process of termination can also give rise to disputes. As the examples are the United States withdrawal from the Paris Agreement and Iran's withdrawal from the Joint Comprehensive Plan of Action, JCPOA. Now, let's take a look at the view from different books about the termination or withdrawal of treaties. Treaties can be terminated through various means such as denunciation, revocation, or expiration. As per Malcolm N. Shaw in his book International Law, treaties can be terminated by notice of termination, by denunciation, by revocation, or by expiration of the term. The process of termination can also give rise to disputes. As per Ian Brownlee in his book Principles of Public International Law, disputes arising from the termination of a treaty can be resolved through various means, such as through negotiation, mediation, or arbitration. Let's see treaties as a source of international law. Treaties are considered as one of the primary sources of international law, along with customary international law and general principles of law. You can check our previous lecture about the source of international law. According to the statute of the International Court of Justice, international conventions, whether general or particular, establishing rules expressly recognized by the contesting states, shall be applied. Now, coming over to the different examples. The United Nations Convention on the Law of the Sea, which sets out the legal framework for the use and management of the world's oceans and their resources. The Paris Agreement aims to address the issue of climate change. The Nuclear Non-Proliferation Treaty, which aims to prevent the spread of nuclear weapons. Examples pertinent to Pakistan is also mandatory to understand. The Indus Waters Treaty between India and Pakistan, which was signed in 1960 and sets out the rights and obligations of both countries regarding the use of the Indus River and its tributaries. The Simla Agreement was signed between Pakistan and India in 1972, which sought to resolve the issues arising from the 1971 war and to establish a framework for the conduct of future relations between the two countries. The United Nations Convention Against Torture, which Pakistan acceded to in 2010, and is legally bound to implement the provisions of the convention. The Extradition Act of 1972, which lays down the legal framework for the extradition of criminals between Pakistan and other countries. That was the end of the first topic of our today's lecture. Let's jump into the next topic, which is the Vienna Convention on the Law of Treaties. First, we will look into the outline of the said topic, then explain it further in detail. Now coming over to the outline. First, we will define the topic. Then we will discuss what is the conclusion, then interpretation, then operation. After that, termination. And at the end, we will discuss different examples. So, let's start our second topic. The Vienna Convention on the Law of Treaties, VCLT, is a treaty that sets out the rules and principles governing the conclusion, interpretation, and operation of treaties. It was adopted by the United Nations Conference on the Law of Treaties in 1969 and entered into force in 1980. Coming over to the definition. According to the Vienna Convention, a treaty is defined as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation, Article 2. This definition includes a wide range of agreements, such as treaties, conventions, protocols, and declarations, as long as they are concluded in writing and governed by international law. Moving forward towards the conclusion of treaties. The convention sets out the rules and procedures for the conclusion of treaties, including the requirement for the consent of the parties, Article 11, the use of diplomatic channels, Article 13, and the requirement for the treaty to be in writing, Article 14. The convention also provides for the use of special procedures for the conclusion of treaties, such as the use of special representatives, Article 7, or the exchange of notes, Article 12. The next heading, which is the interpretation, explains. The convention sets out the rules for the interpretation of treaties, including the requirement that a treaty be interpreted in good faith, Article 31, in accordance with the ordinary meaning of the terms, Article 32, and in light of the treaty's object and purpose, Article 31. The convention also provides for the use of supplementary means of interpretation, such as the travaux préparatoires, or preparatory work, of the treaty, Article 32. Let's discuss the operation. The Convention sets out the rules for the operation of treaties, including the requirement that a treaty be performed in good faith, Article 26, the principle of pacta sunt servanda, or the obligation to keep treaties, Article 27, and the principle of non-interference in the internal affairs of other states, Article 2. The Convention also provides for the use of special procedures for the operation of treaties, such as the use of special representatives, Article 7, or the exchange of notes, Article 12. Coming over to the second last heading, which is the termination. The Convention sets out the rules for the termination of treaties, including the requirement that a treaty be terminated in accordance with its terms, Article 54, the requirement for the consent of the parties, Article 54, and the requirement for notice of termination to be given, Article 56. The Convention also provides for the use of special procedures for the termination of treaties, such as the use of special representatives, Article 7, or the exchange of notes, Article 12. Let's discuss different examples. The Vienna Convention on Consular Relations of 1963, which lays down the rights and duties of consular officials and the protection to be given to consular premises and archives. The Vienna Convention on Diplomatic Relations of 1961, which lays down the rights and duties of diplomatic officials and the protection to be given to diplomatic premises and archives. The Vienna Convention on the Law of Treaties between States and International Organizations or between international organizations of 1986, which lays down the rules and principles governing the conclusion, interpretation, and operation of treaties between states and international organizations, or between international organizations. Examples from Pakistan will give a clear view of the topic. One example of how the Vienna Convention on the Law of Treaties has been applied in Pakistan is in the case of Pakistan's withdrawal from the Treaty of Friendship, Cooperation and Good Neighborliness with India in 1965. Pakistan invoked Article 60 of the Vienna Convention, which allows for the termination of a treaty due to a fundamental change of circumstances, to justify its withdrawal from the treaty due to India's alleged aggression in the Rann of Kutch and subsequent hostilities. This decision was later upheld by the International Court of Justice. Now coming over to the another example of the Vienna Convention on the Law of Treaties being applied in Pakistan is in the case of the Indus Waters Treaty between Pakistan and India. In 2016, Pakistan invoked Article 60 of the Vienna Convention to argue that the treaty was no longer in effect due to India's construction of the Kishanganga and Radal hydroelectric power plants on the Indus River. The matter was referred to the Court of Arbitration, which ultimately ruled in favor of India, stating that the treaty remained in effect and that Pakistan had not provided sufficient evidence of a fundamental change of circumstances. One of the other examples of the application of the Vienna Convention on the Law of Treaties in Pakistan is in the case of Pakistan's accession to the Nuclear Non-Proliferation Treaty (NPT) in 1975. Pakistan argued that it was not bound by the treaty's obligations, as it had not consented to be bound by the treaty and had not been a party to the negotiation and adoption of the treaty. The International Atomic Energy Agency (IAEA) and the United Nations (UN) rejected this argument, and Pakistan's accession to the NPT is considered to be legally valid. With this, I come over to the end of our today's lecture. I hope you like and understand the lecture. Like and subscribe our channel, also click the bell icon to get notifications of our videos. I thank you all.